All right, and Jerry Kagan, is your person in custody? All right, Mr. Porter, come forward. All right, hello. It's too early for Christmas. Oh, no, I'm just joking with you. It seems that Christmas comes earlier and earlier every year and they put everything out. But, all right, so what we're here for today, the state, were you able to tender an offer? Okay. All right, sir, how old are you?
6.
All right, you're 26. Get the calendar here. All right, Norma. On this case, can you set it for a plea deadline date, the week of December 16th?
I'm probably leaving town December 13th, so a couple days before that.
All right, Norma, then can you put it on December 10th?
Then I have the dentist, so maybe the 11th or the 12th.
All right, December 12th.
Thank you, Jim.
All right, once you sign the reset form, you're excused. On that day, you need to let the court know whether or not you've reached an agreement. If not, your next setting will be a trial setting.
Alrighty.
All right, thank you.
Yeah. Great. And right.
John Feliciano.
Mr. Otero, it seems like you were just here yesterday for a jury trial.
Did we bond, John? Violation, second violation.
No, I do not. Let me double check. The last time I checked, there was nothing there. Yes, I don't have anything.
As soon as you said that, my toothache started.
All right, and can I see the file on Christy Brown, please?
Sure.
Christy Brown, if you'll come forward, please. Hello. Hi. How are you doing?
I'm okay.
All right, great. Thank you for dressing appropriately for court.
Yes.
All right, so your attorney just sent an email saying that he is in Johnson County.
Yes.
Attorneys, help me out. Where is Johnson County? I look at
No one
Joseph.
knows?
Say Johnson.
Yes.
Johnson.
Johnson City, straight up 281, just past Line Cove. It's about from 281 and 1604, you got about another hour.
Okay, all right, thank you.
They have a little museum up there.
Oh, they do?
Yeah, it's all about President Johnson.
Wow. And hence the name, I guess, Johnson. All right, so are you employed?
No.
Okay.
No.
So what we're gonna do is we're going to recall your case.
Okay.
And that way your attorney will have a chance to come in and your attorney, will talk to the state. Okay,
I do like how.
all right. Norma, can you put this on the docket for November 21st? All right, they're gonna give you a reset form, so you'll need to be back here on November 21st at 9
Oh, 9 a.m.
a.m.
Okay.
But don't leave the court. She's gonna give you your reset form.
Okay.
All right,
Thank
thank you.
Ms. Brown? Yes, ma'am.
Anyone else ready? If you're ready, just have them pull your file and then I'll call you up.
Email address?
Yeah, I don't have
She
it.
doesn't have it?
No.
Oh,
What? Leha? Yeah, it was an MCR.
See, and you're probably thinking, what is the judge doing? She's just sitting there.
I was just busy doing my own thing until I thought about it, but no, I'd given it before lunch because I want to be ready to go.
Huh? Sometimes attorneys are just staring at me and I always say, why is this person staring at me? I don't have anything.
Oh my God, no, I thought they had it because I asked her, she goes, right up there. I go, okay. And I was just reading the news. I know.
All right, who is here on, well, you are, if you have your client, Andrew Leha, come down. And are you ready to proceed on the,
Yes, Judge, we are ready to proceed.
all right, we're gonna go on the record. Court is calling 2024 CR 6204, State of Texas versus Andrew Mark Leha. Can I have parties announced?
Jason Garrett, state your honor.
Teresa Garcia for the defendant.
And are you Mr. Leha?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney and did you understand it?
Yes, Your Honor.
Are you the same Andrew Mark Leha who was placed on community supervision in 2024 CR 6204 for the offense of theft $2,500 to $30,000 on July 9th, 2024 for a term of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, violating condition number 1 on or about the 30th day of September 2024 in Thurs County, Texas. The defendant, Andrew Mark Leha, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility and up to a $500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, Your Honor.
Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor,
Yes.
and that is to have, to deny the motion, continue on his probation and order moral or MRT therapy.
More recognition
Yeah,
there.
recognition. And then also judge a 10-day jail sanction starting from today. Also, the state will take into consideration two false numbers. One being that he pled true to today, which is 2024 CC 738906. And that is the theft. And then another theft that was previously supposed to be TIC, but was not, but we're included in this MTR is 2024 CC 738391. And that is also a theft. And Judge, also we're asking for a no contact order with all hunting groups.
That's correct, Judge. That is our agreement.
All right, so Mr. Leha, what I can tell you is I'm not going to follow that agreement. I'm going to revoke you. And let me just tell you, and people always say, you know, don't say too much on the record, but I want you to understand the reason why I'm doing it. I understand that they want the MRT, but how old are you?
46.
You're 46. So, I mean, you're at an age, you're supposed to know right from wrong. You can't take what doesn't belong to you. And you are on probation for a theft case. And when you were placed on probation for this theft case, there were cases that were taken in consideration. They were thefts. And then now you're back and now there's a new theft. So I don't think you're a good candidate for probation. So I'm not going to continue you. What I'm going to do is I'm finding number one true. I'll take into consideration 2024 CC 73890, 2024 CC 738391. There's to be no contact with any Home Depots. And I'm going to sentence you to 1 year in the state jail facility, give you credit for any time served. There's a $500 fine, time and money will run concurrently. And I think there was a no contact in that case as well. Let me see which person that was with or facility. And there's a no contact with Dick's Sporting Goods. All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you do have a right to appeal in this case, but that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Your attorney actually did a very good job for you because now you're not looking at all of these other cases. So you should not have any more cases on your books when you come out, but you cannot take what doesn't belong to you. All right.
Sure.
All right. Good luck to you.
Thank you.
All right. All right.
Oh, which number is that? 7389. Okay. So, court reporter for the record, that case being taken in consideration is 2024 CC 738906.
Swap the two and one right.
Oops, I'm so sorry. I thought she was there. All right, who's here on Richard Baker? I'm sorry, Norma. All right,
Talked to 701 this morning, but they're not here this afternoon.
all right. Norma, where is Family Violence? All right, could you have them come down, please? They'll be right down.
Yes, ma'am.
All right, thank you. Just have a seat, Mr. Baker. And Norma, I'm checking my email. I still don't have anything. Okay,
Yes, I was.
okay.
I've had him, he's supposed to email both the court and myself when he has finally completed the paperwork. Judge.
Okay.
I I appreciate the court's patience.
Oh, no problem.
Thank you.
You're welcome.
Jason says he'll handle a hearing.
Okay,
Mr. Baker.
all righty. Richard Baker. Okay. We have a couple of things going on. The first thing we have in the NIGHTMAC cause number that ends in 84. The bondsman has filed an affidavit to surrender surety.
Judge, because their affidavit was so sweeping and broad, saying he just didn't comply with rules, I asked you to deny it because it wasn't specific enough. We can't just have them every time they want to quit. You know, tell the court, oh, this guy's not obeying our rules. Let's at least know what it is.
Okay, on this
But
one.
you said, I'm sorry, Judge.
No, go ahead.
You said, well, find out if you can get them to stay on the bond. Well, we cannot get them to stay on the bond.
Oh.
So you're probably going to grant that. I'd ask you
Well,
not
not
to.
necessarily. We shall see. They're saying that they say that he's a flight risk and will not appear in court as ordered. That's what they,
If,
put in.
if on the new cases, you were to order some sort of electronic monitoring device as a condition of the bond, that could address that issue. But, you know, it's sort of conclusory.
All right, well-
He's in college, he's a US veteran, he's,
well, this is what I can tell you. If you want to call the bondsman, because I do have a hearing set and it says the bondsman is to be
Yes.
present. So if you'll call the bondsman, and would there be any objection if they're able to zoom in?
none from me, Judge.
All right, so if you'll get in touch
Can I
with the
take that
bondsman,
paperwork back, Judge?
yes,
Thank you.
and we'll see what they're doing. All right, who's here on Ortillo Ruiz? All right, and Vashon, this is an application.
Yes.
Court is calling 2024 CR 2499 State versus Otilio Ruiz. Can I have parties announce?
Jason Garrett here for the state, Your Honor.
John St. Heiners for defense.
And are you Mr. Ruiz?
Yes, ma'am, I am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did. Yes, ma'am, I have.
Mr. Oh, no problem. All right, so off the record for a moment. On his application for deferred adjudication,
Yes, Your Honor.
is there any objection to the court adding the last name Ruiz?
No, Your Honor.
Okay,
Thank you, Judge.
you're welcome. All right, we'll go back on the record. Mr. Ruiz, did you review the document entitled Application for Deferred Adjudication with your attorney? And did
Yes,
you
I did, ma'am.
understand it?
Yes, ma'am, I did.
And did you sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
I do waive the waive. You
State-
do waive the reading.
Thank you. State, it appears that you're proceeding on the indictment as presented.
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, did you review the court admonishments with your attorney? Did you understand it?
Yes, I did.
Did you sign it in all the appropriate places? And state, if you need to be at your table to continue,
Thank you, Judge.
thank you.
Thank
Did you understand you're charged with injury to the child of a child or elderly or disabled person, bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney? Just 1 second. We're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am, I did.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do. Yes, Your Honor, I do.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, I did.
Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at a $500 fine. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes, I did.
And also, I'm unsure, I think this is family violence case, is that correct?
No, it's criminal trial division, Judge.
Oh,
Somebody else did the paperwork for me, Judge.
Ah,
You can ask
okay.
me and I can totally help you out.
All right, no problem. I was just wondering, because I was wondering whether or not there was an affirmative finding of family violence,
No,
but
no,
I see
there's
there
not.
isn't.
No, this is not a family. Judge.
Okay. All right, you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph?
Yes.
Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Counsel, are there any such motions?
No, ma'am, no, Judge, there has not.
All right, outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 120 hours of community service restitution, no contact with Conrado Espinoza, that's CONRADO, and the APSE course. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Something.
State, any evidence?
Yes, Your Honor. City Exhibit number 1 with all of its attachments.
No objections, Judge.
All right, did you review the waiver with your attorney? Did you understand it?
Yes, I did.
And did you sign it in all the appropriate
Yes, I
places?
did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we are.
Anything you wish to say on behalf of your client?
Yes, Your Honor. First off, my client is the primary breadwinner for the family. He's the only one working. He has 4 children and 1 on the way. He would ask the court, if considering all these facts, if they would be willing to probate the fine.
Okay. All right, anything you want to say? What have we learned from this? What we've learned is that if you're walking in the middle of the street or if you're driving and someone honks their horn at you, you do not follow them to their home. And this was an elderly gentleman. I bet you were not expecting a dog to come out and come to his defense. What type of dog was it?
Pit bull.
All right. So you had a round with a pit bull that was protecting his owner. And how many times did the pit bull bite you?
3 times.
And where did the pit bull bite you?
My ankle and my thigh.
Was it painful?
Yeah.
I bet you won't do that again, will you? See, so here's the thing. All of this that happens out here with people driving or people walking and people honking their horns at you, you got to let that go. And you can't be following somebody to their residence because you never know what could have happened. And your attorney is telling me that you have children. That could have easily went one, maybe you got rabies and died, or maybe the pit bull could have ended up killing you. Then who would be taking care of your children? All right.
Yes.
All right, this is what the court is going to do. There's a $500 fine that'll be probated,
Thank you, Judge.
2 years deferred adjudication. What do you do for a living?
Diesel mechanic.
Okay. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. 120 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, 60 of those hours will be deemed satisfied. And our order defensive driving. And once he completes that, the remaining of the 60 hours will be deemed satisfied.
Thank you, Judge. It's more than generous.
Yeah. There's to be no contact with Conrado Espinoza. Regular reporting by Zoom or in person. Regular random UAs. And there'll be field visits 1 time per month for 2 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am, I did.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I did.
All right, we can go off the record. In this court, communication is key to be successful. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court.
You can call me
Right.
too.
Okay.
And please tell me, Deputy Laura, I'm hoping they didn't put the pit bull down.
No.
Oh, they did
haven't
not?
touched- No, they haven't touched.
Okay. All right, good luck to you.
Yes, ma'am, thank you.
Yeah. You know, you something, print it out. Sure.
Your Honor, may I return this document to you?
Yes.
The bonding company does not answer.
Okay,
so
well, I'll
nothing
take
I
care
can
of it.
do.
Norma, on this case with Pat Montgomery on Baker, was the bonds company notified? Okay. All right, Norma, you want to see if you can get in touch with the bonds company?
Eagle? Yes, ma'am. I'll give you that number. It's on my screen. They'll answer.
All right, who's here on Reggie Rice?
I am Judge. And I'm appearing for Stephen Gilmore from the Scope Defender's Office.
All right, where's Mr. Rice?
He's in custody.
Hello, Mr. Rice. How are you doing? All right, so today is the day for discovery. State, do you know if the discovery has been turned over?
I do not. I heard the defense counsel.
I believe it has, Your Honor. There are some videos that are currently being uploaded by Mr. Ariola, but it is my understanding that the discovery has been uploaded.
All right, so what I'm going to do is I'm going to reset this for discovery and also for the state to be prepared to tender an offer.
Yes, Your Honor.
And let's see. Norma, on this case, can we bring it back on December 19th for discovery? It's going to be for discovery and for the state to tender an offer to you, okay? And this, I'm putting it this time at that date, so that'll give your attorney a chance to look at everything and go over everything with you. As you know, holidays are coming up, so that's probably the last date I can get you in, okay? All right, you have any questions? All right, we'll bring you back on December 19th. All right, thank you.
Thank you, Judge.
You're welcome.
Somebody. I'm here now. Yeah.
Wow.
You don't put their name there?
I know. I got it. But I can read I'm ready on. Via Real, Joe, via
Yes, it's the same. Yeah. Do you need it? Or do you have it? No, the only one I have is Baker and what I have here. Sure, just give me 1 second. All right, Norma, I just sent it. Yes. Who's here? Mariah Lopez? Hello. Hi, I think this is the first time where I didn't have to sign an order for you to come over to court by force.
I don't think it is, Judge.
Oh, you think there are other times? Okay.
I'm certain that there was at least one other time.
Okay. How are you doing today? Good, how are you? Oh, I'm doing okay. All right, so we're gonna go on the record. Court is calling 2024 CR 6703A State versus Mariah. Am I pronouncing that correctly? Lopez. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Orlando Castañon for defense.
And are you Miss Lopez? Counsel, have you received all discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lopez, did you review the true bill of indictment with your attorney? Yes, ma'am. Did you understand it? Does somebody need off the record? Do we need a mask for, I think we need a mask for somebody over in the box. Nobody's trying to get sick before the holidays.
It's happening.
Who is that over there with the cough? All right, let's give that to Mr. Baker. Do we need to double up on that? Those are pretty thin and flimsy. All right, we're back on the record. Court report, I'm trying to protect you.
Thank you, Judge.
All right. Deputy Laura, do you want to?
For what it's worth,
He's always been that way, Judge, so I don't know that he's any sicker than he ever was every time I ever
Doctor.
talked to him.
Dr. Patrick Montgomery.
I'm trying to alleviate some worry here.
People think that JD means that we're medical doctors. No. All right, we're back on the record. You say that you reviewed the true bill of indictment with your attorney?
Yes, ma'am.
Do you waive the reading of the indictment?
I do, Judge.
Are you proceeding on the indictment as presented?
We are, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary or habitation?
Yes, ma'am.
Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargaining agreement with the state, the court doesn't have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand by entering this plea, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
You believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 2 years in the prison. There are no applications. This will run concurrent with 2022 CR 8673. Take in consideration 2024 CR 5803. Did you understand that to be the plea?
yes,
Defense is at the plea?
It is, Judge.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
guilty,
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all this attachment.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, how do you know these people? Do you know them at all? You can't do this, you understand? And what is happening with this other case that it's supposed to be running concurrently with?
You've already sentenced her to that case. It was a revocation. It was,
Okay.
I believe, back in May. I was not the attorney at that time.
All right. Court will sentence you to 2 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 8673. Take in consideration 2024 CR 5803. There's to be no contact with Alyssa Jade, Jade, Paez, Paez, or Samuel Reimers or Reimers, Rymers, or Brennan, Brennan, Alexander Cornish, or 3434 Oakdale. And that's San Antonio, Texas, 78229. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Yes. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So anytime you're doing custody is a lot of time. So make sure you change your ways. If there's some issue with housing or something else, if I'm still here when you're released, you can come back here. If you can't find a place to stay, I'll pick up the phone and call somebody, okay? All right, good luck to you.
Thank you, Judge.
You're welcome.
Good luck. You know, Judge, there was somebody in my parking lot the other day,
Mhm.
and I saw her with a young child. And I went to go try and give her some help. I said, "Are you okay?" She looked at me. She was like, "No." I was talking to her, and you were the first person I actually thought of her calling. So I was like, who can I call to reach out to see? But then she left and she disappeared on me.
Oh, my God.
And the child wasn't hers. And she said she had her for 2 days. It was very strange, but yeah.
Somebody call me. Are you gonna call the police?
Well, it's like, no, try to get her to call the police. She didn't want to call the police, and she needed to charge her phone. And then I actually went to go try and find her. I met a police officer. I said, "Hey, there's this woman," but I did think of you
All right,
in that situation. Thank you, Jeff.
you're welcome.
Thank you.
That's why you're here. Okay.
They haven't zoomed in yet. Mm-mm. Yes.
The Onion bought InfoWars.
The what?
The Onion, you know what the Onion is?
Yeah.
They bought Alex Jones InfoWars.
Well, my understanding is that the family, that the family of the students killed,
Uh-huh.
they helped pay some of that.
Oh, wow. I didn't know that. So, you
Mhm.
know, here I'm thinking I'm bringing you news and you're bringing me news. Wow.
All right, thank you. Let me see.
That's.
I'm gonna check my email. No, I haven't received a cert of appeal.
Signature.
Sorry? Oh, no. Oh, thank you, man.
All right, who's here on Joe Villarreal?
I am, Your Honor. I'll be covering this for Monica Guerrero.
Okay, and are you all ready to proceed on the motion?
We're ready, and we have a partial agreement.
All right, court is calling 2019 CR 6683 State versus Joe Villarreal. Can I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
The attorney record is Monica Guerrero. I work for Monica Joseph Dateson. We're ready to proceed on Mr. Villarreal's MTR.
All right, and are you Mr. Joe Villarreal?
Yes, ma'am.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Mr. Statesman, do you have any questions to ask him in regards to your representation?
And Mr. Villarreal, are you okay with me proceeding forward in place of Ms. Guerrero today? Yes, sir. Thank you.
All right. Mr. Villarreal, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Villarreal who was placed on community supervision in 2019 CR 6683 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on August 1st, 2019 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 2 on or about the second day of March 2023 in Bear County, Texas. The defendant Joe Villarreal did it in there illegally used a controlled substance, namely methamphetamine, and violation condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violating conditions.
Any objections to the waivers?
None.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 5 years in the prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Partial, Your Honor.
All right.
An agreement on revocation of the, grant the motion and revocation, Your Honor. The state is recommending a lesser than 5 years to 4 years, which were unagreed upon.
All right,
And I'm sorry, the state has also taken into consideration cause number 2024 PF 20151, which is possession case.
all right. And defense, what are you requesting?
Your Honor, we had an agreement for grant the motion, revoke. We ask that you reform the judgment to reflect 3 years TDC instead of the 5 years. I understand previously he pled to 5 years. He agreed to that back in 2019. Mr. Villarreal is accepting responsibility on the new offense. He was homeless. He did not himself cause a disturbance on this new offense. It's a homeless encampment. Other people were damaging property.
Mhm.
He was, they identified him. He had a warrant for this MTR, but he cooperated, had a substance in his pocket, and the state is going to dismiss that case. He did SAT-F previously before he did treatment. He was going to church. Unfortunately, he had a relapse. He's really asking for his back time credit, the time that he had at SAT-F, which is 119 days. And he completed, I believe he completed because on the court summary, it says residential facility SAT-F, start date October 26, 2022 through February 22nd, 2023. And it says number of days completed, 119 days.
All right.
So
And
he's
state,
asking.
you
for
may
that.
be excused.
So he's asking for the 119 days, and currently I've already checked with the court. He has 207 days credit in the Bexar County Jail. He's asking for 3 years mercy on the court. If you could reform the judgment, reflect 3. If not, we're hoping that you would follow the DA's recommendation of 4.
All right, and probation, did he successfully complete SATA?
Judge, he
completed the inpatient part of it, but not the outpatient part.
Okay,
And may I ask my client a question?
sure.
Mr. Villarreal, on the inpatient SADF, did you ever obtain a certificate of completion?
I did.
I'm sorry, you need to speak up.
I did.
You finished SADF
Yes, I did.
inpatient, completed it successfully?
Yes, sir.
If you want to ask him any questions, you can, Your Honor.
All right, so where did things go wrong? Because I know I tell people if there's some issues, all they have to do is contact their officer. Why didn't you contact somebody when you had a relapse?
I had an issue with my PO that I had at the time. I was trying to communicate with her, but to me, I felt that she wasn't trying to.
Here's the thing, that doesn't hold water with me. You know why? Because I tell everybody, speak to your probation officer, and if you feel as though they're not addressing your issues, you can always come back to court.
You know, I don't know how to like really explain myself to that extent, but I know you said that, and I know, I mean, I'm like a shy person, and, I could have done that, but just wasn't sure, too much sure. But like I said, it's not too much of an issue, but it's just, I guess,
All right.
discussion that we were having, you know, between me and my probation.
All right, so here's the thing. If you don't get your life together, one or two things are gonna happen. Either you're gonna end up continuing to be sent to prison, or either somebody's gonna be identifying your body because you got a hold of bad batch of drugs, all right?
Yes.
So you're gonna have to change,
Uh,
and nobody can help you if you don't want it for yourself, okay?
most definitely.
All right, the court is finding two true. The court will grant the motion revoke. Take in consideration 2024 PF 20151. Court will sentence you to 4 years in the prison, give you credit for any time served, and credit for any successful completion of inpatient treatment. And I'll order the therapeutic community. In order to be in that program, you'll have to request it as well. I have no jurisdiction to force them to place you in that program, but it's to help you maintain your sobriety.
Yes,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations that are in the motion, not the fact that you are on community supervision. Do you understand?
Yes.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Copies.
All right, are we ready on Baker?
Sure. Yes, ma'am.
She gave you your SADF?
Yeah, I'm trying to see if I
Yep,
get
the
the-
bondsman is on the Zoom.
have a few.
Baker. I wasn't telling you what you got.
Hello.
Yes, the increase. Okay.
All right.
Hello, Mr. Rodriguez.
Okay, yes, ma'am.
All right, I can't hear you.
Yeah, I had my mic off. Can you hear me?
All right.
I'm trying to get the volume up so I can hear you. Okay,
All right, I think I hear you better now. All right, what we're here for is you're asking to be taken off of this bond. You filed an affidavit to surrender surety.
yes, ma'am.
Are you aware of Mr. Baker's case?
Yes, ma'am.
All right, so we'll proceed. The court is calling, let me see. And I just have an affidavit to surrender surety on one of the cases.
Yes, I had two cases. One of them is completely paid off. And he just
Okay.
paid on the other.
All right, so the one that he's seeking is the one that we're going to proceed on. Court is calling NIGHTMAG number 724084, State versus Richard Nelson Baker. Can I have parties announced for the record for the state?
Raymond Saldana.
Defense?
Pat Montgomery.
And are you Mr. Baker?
Nelson Baker, yes.
Yes. All right. Is your first name Richard?
Yes.
Okay.
You said Nelson.
Yeah, Richard Nelson Baker.
No ton.
Ah,
No
we need to
S.
correct that then, because it's listed as Nelson. All right. And the bondsman has filed an affidavit to surrender surety. And defense, are you objecting to the court signing that?
I am, Judge. I'd like to leave the bond as is and address the new bond, which is currently, it's not here right now, but it's currently a remand without bond. Mr. Rodriguez isn't necessary for that case.
Okay. All right. So with regards to this case, Mr. Rodriguez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Manuel Rodriguez, Eagle Bell Bond.
All right, so Mr. Rodriguez, the court is in receipt of an affidavit to surrender surety. Defense counsel says that it is not clearly defined the reason for you're wanting to be removed from the bond. And what you put in the affidavit is that you believe he's a flight risk. Are you able to expound for the court, please?
Yes, the reason on the fight, this is the standard statement on the
Okay, I'm sorry,
None
just
of
one
us,
second.
yeah.
All right, are you able to move closer to your microphone?
can you hear me?
All right, let's do this.
Let me do the output, see what's wrong with the
Okay.
output speaker. Oh.
All right, let's do this. Is there any objections if he were just to call my phone and I can put him on speakerphone, but since everybody has seen him, any objections to that?
Probably hear him better that way, Judge.
All right.
No objection.
Okay, Mr. Rodriguez.
How is
can
that?
You text, repeat yourself now?
Yes, Manuel, this is Manuel. I just found it's actually under the input. I guess I was looking at the wrong one.
All right, to the court report, are you able to hear him better now or no?
A little better, yes.
All right, can you just say something? Let's see if we can get you.
My name is Manuel Rodriguez with Eagle Bell Bonds.
Is that good, or do you want him by phone? All right. Can you put in the chat box your number and I'll call you?
Okay, where's the check box?
Oh, yes. And if you need to sign off to answer the phone, you can. And I'm going to call you right now.
You have my number?
Yes, Norma is giving it to me.
Okay. Yes, ma'am.
All right, thank you. All right, so can you explain why you do not want to be on the bond?
And it didn't look like nobody was gonna bond him out. And I've been having problems with him as far as his payments are concerned from before.
All right, and with regards to what you put in the affidavit about the flight risk?
That's standard portion, standard item on the off bond.
Okay, so can you explain to the court and to the defense counsel, what is your reason for not wanting to be on this bond?
I've had Richard on bond for over a year now. My biggest problem with him was at first was calling in and making his payment. You know, we had two different bonds. One of them was completely paid when his mother got him out. The second one, he was gonna make payments. And at first he wasn't calling in nor making his payments at all. So when he got arrested and he wasn't, getting busted out, I waited, I think it was a week or two, maybe longer, because he had promised to make a payment on the 2nd of November. And he had gotten arrested and he never made that payment. And these were back. So since he wasn't getting bonded out, I just did a surety surrender. I didn't feel it was right for me to do surety surrender on both bonds because one of them was paid off completely. So, I figured on my own right, I figured I only had the right to get off on one of them because he was refusing to pay.
All right. Any questions, defense?
What kind of payments was he supposed to be making?
Originally, and I've got the arrangements here. It was $500 a month, started on the 10th of November. His first payment that he made was a $250 payment on February the 2nd. The second payment was of $500 on the 29th of February. The third payment was $500 on May the 31st. And then he made another payment of $500 on August the 2nd. And then on September the 1st, he made a payment of $500. And that's all he's paid.
Since your affidavit did not cite to missed payments, will you agree to withdraw that factually inaccurate affidavit where you said that he was a flight risk because you always say that in every case, and instead allow him to make payments to you once he is released?
We all in agreement that he makes up his payment that he's behind and he will not miss another one. I'll agree.
So, if he is to be released on his bond, his funds are at his home with his mother, and he will contact you and make those payments. I ask you, sir, to withdraw this factually inaccurate affidavit of surety to surrender so that the judge can set bond on his new case, which was previously set at $20,000. He can hire you if he deems fit on that case as well.
Well, will he get bonded out?
Yes,
Like
sir.
he's back on the bond.
Indeed, but there's still one other case that no one's made bond on yet. But that's not before us right now, sir.
But if I make, why should I retract the off bond if he's gonna stay in jail?
We don't know that he's going to.
He hasn't done nothing in September.
Well,
When he got arrested.
that's not necessarily a legal reason. It's very similar to telling a judge that you always say a person's a flight risk anytime you ever ask to get off bond. You're not supposed to do that. It's similar here. If he's on bond and you have a contract, you don't get to quit on the bond simply because he's in custody again. We're asking you to withdraw the factually inaccurate affidavit of surety to surrender. You're free to file another one and
Okay. I'll submit it as the fact that he doesn't make his payment.
gotcha, sir.
And I'll take off the out.
Gotcha, sir. And in the meantime, I will try to get him to make bond on his new case and get you your payments so that you don't feel compelled.
Oh, what I'm gonna do is I'm gonna retract this one and I'm gonna issue a new one that says that he doesn't make his payment and he's not a flight risk.
I got you, sir. But in the meantime,
I'll correct.
I'm just trying to get him out so he can get you your payments, sir. That's all I'm trying to do.
So just because he's out doesn't make he's gonna make the payment. I've had bad experience with him.
I hear you.
They never answer his phone. I called his mother. His mother said his phone is working. He called me from his mother's number and he says his phone was stolen and he doesn't have it.
I hear you, sir. I'm just trying to get him out so he can get you your payments. I have no more questions, Judge.
All right, so,
Can I ask you a question, sir? Can you guarantee that he's gonna make the payment?
No, sir, I can't, but he does.
all right, so here's the court's question. So my understanding is with regards to this affidavit to surrender surety, you are going to withdraw this one, is that correct?
If he agrees to make his payment,
No, well, here's the thing, I can't get involved in any contractual agreement, but my understanding is that the affidavit, there's a misstatement in it. So I can't grant this affidavit to surrender surety. Of course, if you file a new one and put the correct things in it, then the court will hear it. And if it's correct, then I'll have the option of granting it. But just this specific one where it says it's a flight, he's a flight risk, I think the testimony is that people misspoke. I'm just gonna say misspoke and put something unintentionally in the affidavit. That's how I'm just gonna put it. And so are you withdrawing that? And then you'll refile another one if you wish to refile another one. All right, so that will be withdrawn. All right, thank you so much.
Thank you, Mr. Rodriguez. May I address the court?
Just one moment. I'll do it.
Yeah, I'm just gonna keep that.
All right, so now where we are, on that case, the affidavit to surrender surety has been withdrawn, but just so you know, the bondsman has stated that they're probably gonna file a new one with different information with regards to payments or whatever else, you understand?
Yes.
So we're done with that case. Now this one, the Night Mag 724083, what is going on here?
That's the one that the bond is fully paid off and the bondsman did not file a motion to get off the bond on that case.
All right, on this one, we have a violation report.
Yes, ma'am.
And have both parties had a chance to view the violation report?
Can I just give a quick? The violation report alleges the new number one pending in County Court 14 of interference with a telephone call. And it alleges a family violence subsequent offense, which is on your docket for today. That's a PF case as well, Judge.
Okay. I'm sorry? No.
Yes, Judge. We have reviewed it.
All right. So on this case, state what will you be requesting on the violation report?
We would be asked that the bond be increased to 100,000 on each case.
All right, defense?
I'd object to that. I'd ask the court, at least from a bonding perspective, to take into consideration whatever bonding decisions you may make and apply them to the PF case rather than applying them to the two cases with Mr. Rodriguez, because it will only result in Mr. Rodriguez getting off bond on both of those cases if he's unable to make bond. You're about to take up the matter of the family violence subsequent, the PF that's in your court. I had asked you last time we were here to, strange for a defense attorney to do this, but I had asked you to remand him without bond for a week rather than let the bondsman off the bond so that we could sort all this out and try to preserve these two very expensive bonds for this man.
All right, yeah. I'm so sorry. Could you print out the PF cases for me? So,
That's just one that's in this court.
so it's the court's understanding then that defense, you would agree to $100,000 bond on the PF case?
If that's what the court wants to do, you can set any bond you want, Your Honor.
No.
I don't know that he'll be able to make it, but my goal is to preserve the bonds that exist in the two cases before you. And so on one case, the bondsman himself has said he didn't think it would be fair to, when he took has already been paid the full fee to quit, so he didn't file an affidavit of surety to surrender. On the other one, he may or he may not, depending on if he's paid in the future. And we know we're gonna have to make a new bond on the new case. $100,000 for a F3, perhaps a little steep, but I do understand that he was on bond for these two cases already. I just ask you to consider it in the context of the PF case and not within the two night mag cases.
All right, so with regards to the nightmare case, as far as increasing the bond, in order to increase bonds, there needs to be a hearing and witnesses need to be called because the rules of evidence apply. So in the first violation report, what I'm going to do and state, if you wish to have the bond increased, you can have witnesses come in at a different date. I'm going to continue him with his conditions of no contact. But in that case, what I'm going to do is I'm going to order full GPS.
That's fine.
All right, now let's move on to the 2024 PF 20375. In that case, has a bond been set already?
My understanding is what the bond was set at 20,000 when it was max.
It was set at 20,000 when he was magged. Then the court was, I thought, this close to granting the affidavit of surety to surrender. I said, Judge, don't touch the affidavit of surety to surrender. If you want to keep him in custody, take care of that on the PF case. At that point, the court changed the 20,000 to remand without bond for 1 week. And here we are now. And there is currently no bond set on that case.
All right, so there's no bond set on this case?
That is correct. It was at 20,000, but it went to remand without bond to avoid surety to surrender.
All right, so then in that case. Thank you. So in this case, then, states you're requesting $100,000 bond?
We initially were requesting the 100,000 on the Agasol second degrees, but if the court would like to entertain 100,000 on this case because of the bond.
That's even more than what, sorry, didn't mean to interrupt. That's even more, if their request had been raising both of the 75s to 100, it was a 25 increase.
Well, this is what I can tell everyone. He is currently remanded without bond on this case, and there's a judge's warrant.
Yes, ma'am.
If you all want to reset that particular matter to have a hearing, we can have a hearing to set his bond. State, if you want to bring in witnesses, you can bring in witnesses. If not, we can just go forward through using police reports.
Let's go forward using police reports.
All right, so I don't have any.
Have it ready right in front of you.
Wow. Any objection?
Not judge, not for the purposes of the bond hearing. This is his brother, Your Honor.
Okay.
You read it.
All right, the court has reviewed the police report. All right, the court will hear argument unless there's any witnesses from either side.
No, it's.
Nothing further from defense as a proffer. We mentioned to you last time. He's a veteran. He's got longstanding ties to the community. I think the ankle monitor is going to cost him another 300 or so a month when he gets out. He'll be making payments to Mr. Rodriguez when he gets out. I'd ask the court to reinstate the original $20,000 bond. And if he makes that bond, he's still going to have to make an additional $300 or so monthly for his full house arrest.
All right, so this is where we are, Mr. Baker, and I want you to know that I listened to both sides of the argument. You were released on bond for 2 aggravated assaults with a deadly weapon on July 12th, 2024. And then now, October 19th, 2024, there's another assault. And I've read the police report, and it appears that a baseball bat was involved, which technically could be considered an aggravated assault with a deadly weapon, because the baseball bat can be considered a deadly weapon. What I'm gonna do is I'm gonna set your bond at $100,000 and I'll order full GPS. And I'm sorry, what is the complainant's name?
Patrick Baker.
All right, there's to be no contact with Patrick Baker. All right, and then there's no need for a setting because these haven't been indicted yet. But
There
if
is no
you
setting.
if you want to have it come in at a different time, if you want me to reconsider the bond amount, you can always come back.
Yes, ma'am.
All right,
ma'am.
thank you.
Excuse?
Yes.
And we also had a no firearm possession as a condition of bond.
All right, and there's to be no possession of any firearms.
It's already a condition on the other one.
All right, thank you.
Yes, sir.
Thank you, Mr. Rodriguez, for zooming in.
Thank you, Mr. Rodriguez. Oh, sorry.
And my day.
Oh, man.
No, no.
Hi. Yes. Oh, no, just give me 2 seconds. Let me put these notes in and then I will give it.
Yeah, I'll talk with them. We're both sitting down, so, yeah,
It's never a dull moment in here. I like.
You just never know what's happening.
I was like sitting, I always learn something, sitting and watching.
Yeah, we have to put everything in Odyssey now.
Yep, that's this nice lady I'm speaking with right now.
All right, so I did speak with the sheriff to see if I could
Yeah,
get that done.
yeah,
And he said,
it's a no, right?
well, he said the security issues, we've done it in this court before.
Mhm.
But he said the security issues are so great.
Yeah.
I mean, if you want to try calling over there to say please, then maybe, but
Police has never gotten me far at the jail.
no, it's possible.
It's true. Well, I did, while I was sitting there, I did e-file a motion just ordering basically the information on here. And so I don't know if you're okay if I follow up with Norma once it's accepted, maybe you would sign it.
Yes,
Just so
sure.
that I can have that for them. The family's plan is to bond her out
Okay,
for it. But I think well, I won't voice the concerns.
yeah, I
but
know, yeah.
That's why they wanted her to have to come to court
Yeah.
the following.
If I
day.
were you,
I love it, yes.
All right, did I complete Joe Villarreal or are we still doing that? Okay, I don't know why I have this case. Joe Villarreal. Here. All right, and I just received the application from Jones.
Yes, Your Honor.
All right. All right, he's not in the,
You should be in the breakout room in the back of the.
no, he's not on the Zoom.
Your Honor, I've called him 12 times today.
Okay, Jonathan Alfaro. Oh, how's it going?
Hello.
Oh. Okay. All right. We're just waiting on the sanity evaluation.
Correct.
All right, what is the status on that? Do we know?
I don't know. Judge.
I don't know, Judge, but I'll find out.
Okay, let me send an email. What is your client's SID number?
The number
I'm sorry, what? 11? All right, thank you. All right, I just sent them requesting an update on the sanity eval. But what we'll do is we'll recall this back in December to see if we have an update on the sanity.
That's fine, Judge.
All right, Ms. Ferguson, I need a date for sanity. Update eval. All right, we'll come back on December the 19th to see where we are on the sanity evaluation. And I just sent an email and council, once I have a response, I'll forward the email to you in the
Thank you.
state.
Thank you, Judge.
All right, thank you.
Thank you.
You're welcome. Yes. This is gonna be the longest plea ever. He still hasn't signed in. So I just want you to know I'm keep.
He says that he's on there, Judge. He says wait for hostess.
No, he's not in. Let me see, let me make sure that they have the right, maybe he's on a different Zoom link.
You send it to me, Judge, I'll send it to him.
All right, I'll send it again. I just sent it.
Thank you, Judge.
You're welcome.
I mean it, thank you.
Oh, no problem. Yes.
So you sent the email to him?
Now I sent it to Norma to send to him.
Okay, I'm sorry.
And then, Rashawn, I'll send it to you as well.
Oh, great. I gotta get him to check his email.
He still hasn't zoomed in, yeah.
Okay, I'll stay waiting.
I gotta call him real quick. Okay. Click on this thing and fill out this email. That was a bill, basically. Overall. Not sure we could accomplish. Now that's her.
Ah, here he is, Eric.
Excellent.
All right, yeah, you can go back to well, I'll move you to number 2. And Eric, I'll move you to number 2. Eric, click on it to go to breakout room number 2. All right, who's here on Eduardo Reyes?
Come up here, up to the mic.
I was just asking for a new attorney, miss. I ain't been able to get that yet.
Oh, you can get a new attorney.
Please,
Yes, most definitely. You need to hire one.
yes, I don't need him representing.
No, you need to hire an attorney.
I know. I
All
don't
right,
need him.
so until you hire an attorney, this is your
It's been
attorney.
very rude and I'm not gonna accept it.
All right, here's the thing. You-
I'm just trying to work my case, man.
No,
I
here's,
went to Sash and I did my work.
okay,
I was there for 7 months doing my work to the best of my ability. I passed every test. I passed my evaluation
mhm.
and there's still no improvement or nothing or
Well,
anything.
let me explain something to you. I want you to listen to me, okay? So whenever you go to SASH
There's been a lot of
and you
mistakes.
pass, I know, here's the thing. Listen,
My
all
rights
right?
have been violated.
Will you listen? Are you gonna listen? Because if you're not gonna listen, I'm gonna have to send you back. All right. So when you go to SASH and they restore your competency, it takes a while. There actually has to be a hearing in front of Judge Carruthers to say that your competency has been restored. And then your attorney can work on your case. That's how it works.
I've been doing that.
So here's my
studied that.
question. Have you
Studied all that.
studied?
Yes,
All right. And did you learn everything?
most of it, yes.
All right. Is there anything that you didn't learn?
I know that it's bothering me that I've been asking for a new attorney and that's what I need.
Mhm. All right. So this is your attorney. So
Not my
here's
attorney.
my question. Have you had a chance to review the evidence that the state has, that they say they have against you? Have you had a chance to see that?
There needs to be a lot of volunteer work. There needs to be a lot of that going on. Because there ain't nothing really, it's just been the same since I left. That's what it seems like. And I've learned. Best believe I learned and I'm trying to do right. I learned from that program.
Yeah.
The ups and downs, all that.
Mhm.
And I'm just asking for another chance, that's all.
Okay. No,
And I work for that. And that's all I'm asking. I want some probation at least.
all right. So let me, I want to tell you something about that. I understand that you're saying you did the work. And I appreciate you're doing the work because it takes a
I got
lot.
all my homework here.
Oh, no, no, no.
My folder with my legal mail, I couldn't get that. I couldn't even bring that to show you that.
Oh, no. Here's the thing. You don't have to bring that to show me because I believe you. I believe you when you say you did the work. I
Sure.
believe you when you say that they said that you've been restored. Okay, so you don't have to show it to me because I believe that. So then the next step is this. Counsel, have you had all of the discovery from the state?
I have the discovery judge, but he was just transferred from the hospital and the restoration hearing was about a week and a half.
Okay,
And so I have not had a chance to show him on Zoom what we have.
all right, so
The pandemic.
let me, wait a minute, let me stop.
COVID, all that is took place.
All right, here's the thing. I want you to listen to me. All right. The state is here. Your attorney is here. Do you want to see today the information the state has? Or do you want
I'm
to
not
set it
gonna
for another?
sign 10 years.
I'm not, here's the thing.
No 10
Then,
years
no,
time, TDC.
no, this is
I'm
what
not
you,
gonna
no,
sign that.
this is what, so I know what's going on now. What's going on now is he does not like the offer that has been extended to him. So what we'll do is we'll set this for jury trial and a plea deadline date. Ms. Ferguson, state, how long do you expect this trial to last?
Judges, it should. With jury selection, probably possibly 3 days, Your Honor.
All right, could I have a jury trial date for him and plea deadline date? It'll be the same. And Deputy Laura, when he's brought back, he'll need to be brought dressed for trial. All right, so we're gonna bring you over December 9th for jury trial. All right, thank you.
New attorney, with the new attorney,
This will be your attorney unless you hire one.
I don't need him, I don't want him as my attorney.
All right, thank you very much for informing me of that. All right,
Maybe excuse you.
yes.
Thank you.
Oh, could you make sure that you do an acknowledgement of discovery?
Yes.
All right, thank you. All right, thank you. And what page is Reyes on? All right, thank you. All right, John Valenciano,
Already, Judge.
and then after that, it will be your client.
Does he have permission to come out, Judge?
Yes. And we'll see you on the 19th.
Yeah, on Monday.
Yes. All right,
Either Monday or Tuesday.
it's Monday.
I have Monday.
Yeah,
I
it's,
think the 19th is Tuesday.
oh, the 18th, you're right. Thank you.
I don't want to get here a day early or a day late.
Yeah. And then we'll, I think we're gonna do at 12:30.
I'll do it. I'm gonna come to court and then bring it in after court.
Okay. All right, court is calling 2024 CR 007380 State versus John Valenciano. Could I have the parties announced for the record? State,
Jason Aaron.
defense,
Mick Aguilar on behalf of the Honorable John Vinciano.
and are you Mr. Valenciano?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
Yes, Your Honor.
Did you review the application for community supervision, sir? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment?
I did, ma'am.
And did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Valenciano, did you review the court admonishments with your attorney?
I did, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I understand, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state? I'm sorry, just one moment. All right. Did you understand by entering this plea, you were giving up those rights?
Yes, I do, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That would be my opinion, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Valenciano, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Everyone, just give me a moment. I'm just reviewing something.
Judge, you were talking about where an American citizen, he was born in Oregon.
Okay,
Does that count?
I don't know, not with the Ducks.
I think they're like number 2 in the nation.
Mm-hmm. I'm sorry, I was just checking the judgments.
Second
Yes, that's why I was like, what? All right. Did you review the plea bargain page with your attorney? Did you understand it?
I did, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There isn't a fine. There's an affirmative finding of deadly weapon.
Oh, Judge, can I look at that?
Sure.
We had one prosecutor that did the deal and the second prosecutor. that-
Do y'all need a whiteout?
Hey, Judge, you know what? This was sort of a mistake. I think I need to redo this real quick.
All right, you want to do whiteout or?
Actually, it looks like I might want to redo the whole thing.
Okay, all right, thank you. All right, just step back. And all right, so what I'll do is I'll take up Mr. Eric.
No.
Yes. Yeah, he's back.
Thank you, ma'am.
He's here.
All right.
All right, Mr. Jones, I need you to unmute and I need you to start your video. All right, court is calling 2024 CR 007042 State versus Eric Jones. Can I have parties announced for the record? State,
Tony Ariola for the state.
defense,
John St. Heinrich for Mr. Eric Jones.
and are you Mr. Jones?
Yes, ma'am.
Counsel, you received all discovery.
I have, Your Honor.
Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jones, did you review the document entitled Defendant's Consent to Plea by Video Conference with your attorney? Did you understand it and sign it?
Yes, ma'am.
Any objection to the defendant appearing by Zoom, state,
No, Your Honor.
defense?
None, Judge.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? And did you electronically sign it?
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do so waive the reading, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Jones, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
No.
I want you to hear me. The rights that I've gone over with you, did you intend to give up those rights? Did you intend to give up those rights and enter into a plea bargain agreement?
Yes. Yes, I did.
All right, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Judge.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
No, Judge, there hasn't.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours community service restitution in the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 with attachments.
No objections, Judge.
State, you may be excused. Did you review the waivers and stipulation with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
All right, anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, State. I'm reading the police report. There was an unauthorized use of a vehicle. So I'm wondering what is going on with that case? Is there a pending case? All right, while he's looking into that, Mr. Jones, where are you currently? What county?
Clay County.
I'm sorry, where?
Clay County, Missouri.
Okay, and is that where you're living?
Yes, ma'am.
All right, do you have any children?
I do.
What are their ages?
I've got a boy and a girl with my first wife. She's 18, getting ready to be 18. He's going to be 16. And my 2 boys with my last one, my one, he's getting ready to be 12, and Kyler is going to be 7.
All right, and do you have contact with them? Do they stay with you?
No, I try to go see them and stuff. They live in North Carolina.
All right. Are you employed?
Yes, ma'am.
What do you do?
I am head of maintenance at the Microtel Inn and Suites.
Okay. All right. Do we have any information?
Not yet, Your Honor.
All right, the court will sentence you to a $1,000 fine. That will be probated. 2 years deferred adjudication. Proof of employment within 40 days. No employment as a home health care provider or with minors. 90 sober meetings in 90 days.
Yeah.
Regular reporting by Zoom or in person. Regular random UAs. 100 hours of community service restitution. I'm going to order parenting classes. Once that's complete, the community service hours will be deemed satisfied. And the DOEP course or its equivalency. And transfer to Clay County, Missouri. All right, probation, is there anything else? Is there anything else you need from the court to be successful?
No, Judge.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
All right, and did you review the trial court certification of defendants' rights to appeal with your attorney?
Yes, Judge.
All right, what's going to happen now is I'm going to send you to a breakout room. Probation will meet you there and go over conditions. And the state and your attorney will see if there are any other outstanding cases. And if there are, I'm sure they'll take care of them. So I'm sending you to breakout room number 1. If you'll go there, and counsel, if you want to zoom in and be in the breakout room, you're more than welcome to do so as well.
Appreciate it, Judge.
Thank you.
Thank you, Your Honor.
You're welcome.
May I be excused, Judge?
Yes,
Thank you very much.
you're welcome.
Thanks. Yeah.
Y'all ready?
Same person.
Okay. All right, Mick, you ready?
Yes, Judge.
Hey, Judge, just before we get on the record, I did take that apart and put a brand new one on.
Okay.
So I'd like to put that on the record.
Oh, no, it's fine. Y'all agree that it's.
Yes, we both signed it.
All right, we're back on the record and 2024 CR 007380. So did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. State recommends community supervision, ignition interlock for half the term, and 2-year driver's license suspension. Did you understand that to be the plea?
Yes, Judge.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pre-trial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, of any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution, and 10 days in the Bexar County Jail as a condition of probation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I did, Your Honor.
Then to the offenses charge, how do you plead?
Guilty, Your Honor.
State any evidence.
City Exhibit number 1 with all the attachments.
And Judge, for purpose of this plea, we have no objection.
All right, state two may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
I did, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
I do, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If you would consider, Judge, we'll agree to any post-sentencing changes or necessary requirements.
All right, anything you wish to say on behalf of your client?
No, Judge, I met John back in January of this year. He did struggle a little bit with alcohol. There were at least 2 violations. I don't recall exactly what the breath scores were. He's been in San Antonio for the last year. He's been in jail now for over a month. He would like you to strongly consider following the recommendation of the supervision for 5 years. He understands that he does not drive without ignition interlock, although he does not have a driver's license at the moment. I understand he's the caregiver for how many?
4.
4 kids.
Okay, yes, Your Honor.
All right, and what are their ages?
It's 13.
Okay.
And 6. It's 7, and then there's a 9-year-old.
Okay,
I'll put him on the spot there, Judge.
that's okay. He
You put
did
him
very
on the
well.
spot. It takes a second to figure out the
Yes.
ages.
No, he did very well. All right, this is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's $1,000 fine, that'll be probated. Ignition interlock for half the term, 2-year driver's license suspension. We'll do a TAP evaluation in custody, follow the TAP recommendations. 10 days in the Bexar County Jail as a condition of probation. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 4 months. We'll do a referral to felony drug court in custody. Felony drug court will probably be able to see you first thing next week. DWI education, victim impact panel live, and 120 sober meetings in 120 days. Probation, is there anything else he needs?
No employment as a whole.
I'm sorry, thank you. Proof of employment within 40 days of release, no employment as a home health care provider or with minors. And I'm sorry, there's 150 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, it will be deemed satisfied. You're welcome. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You are one of those people who cannot drink at all. You understand?
Yes, Your Honor.
Anything can happen when you drink and drive. You can end up killing someone. You can end up killing the children that you care for. Usually what I've discovered is when people are involved in accidents, and I'm sure your attorney will tell you this, the people who always end up getting hurt is not the person who's driving intoxicated. It's usually someone else. So if there's anything you need, you feel as though probation is not addressing it, you can always come back to the court. If there's anything you need to maintain your sobriety, that's the key thing, right?
Yes, ma'am.
You
Yes, Your
can
Honor.
come to court. Don't feel ashamed to ask for help to maintain your sobriety, because that's the key. You got to know what you need to do. You understand?
Thank you, Your Honor.
All right. Good luck to you. Okay.
Thank you, Your Honor.
Thank you,
Thank you.
Judge. Can I take my wife's best and ever cup with me?
Yeah.
She said you were holding it for her. Judge, we'll see you Monday.
All right. Thank you. Have a good one.
Judge Ladford?
Yes.
Hey, Judge, I just have some
Cases that were just true build.
Okay.
And I have these that I multi-counted into a single one.
Okay, just give me a second. Let me put this in the system and then I'll do this.
Yes, Judge, thank you.
You're welcome.
Thank you, Judge.
You're welcome.
You have a good one.
All right, you too. All right, so we have Hank Maldonado remaining.
Morales.
All right.
Yeah, finish, paperwork.
All right, and can I see the file on Raymond Lee McKinney? And then I need the file on Sandra Torres and Miles Fenton.
Norma's gonna do something to both of us.
I'm telling you, Big Trouble in Little China deserved an Oscar.
That is a cult classic.
It is.
I love that movie.
You know what? I don't drive any faster than I can see.
I was in my car, the Pork Chop Express.
And you know what? When that man taps you on the shoulder and says, "Have you paid your dues?"
Yeah.
You tell them, "Yes, sir, checks in the mail." I love Big Trouble in Little China. All right, Jonathan Morales. Court is calling 2024 CR 5806, State of Texas versus Jonathan Morales. Can I have parties announced for the record?
Tony Arriola for the state. David McLean for the defense.
And are you Mr. Morales? Counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
I did, Your Honor.
Mr. Morales, did you review the application of community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
I did.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
The state proceeding only on count 2, we waive count 1.
Any objection?
No objection.
All right, the court will find that the state is in compliance with discovery. Mr. Morales, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
I did.
All right, according to count 2, you're charged with unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is and was.
Mr. Morales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution to Joshua Ochoa and Ahani, Ahjane Esther, in the amount of $500. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver? Oops.
Sorry. Just to clarify, just here for the record for the state, the $500 was going to be owed to Joshua Ochoa and Ajane Easter. That would be open to be determined.
All right, thank you.
That is our understanding, Judge.
All right, so then according to the plea bargain agreement, restitution is to be determined as it relates to Easter. And then the restitution for Joshua Ochoa is $500. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney and understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 150 hours of community service restitution, and no contact with the complainants. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in count 2, how do you plea? State any evidence.
State offer State's Exhibit 1 with attachments. Your Honor, reviewed that with my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and consent with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client takes full responsibility for what happened. He is willing to abide by all the terms that were proposed by the state regarding this probation. We would ask the court to follow our plea bargain.
All right. All right, so state, I'm inclined to go ahead and let Joshua Choa obtain his $500. But honestly, I don't know who would think that a vehicle that has a value of $10,000, they can pay $500 for it. So I'm sort of feeling some sort of way about giving him $500 when, you know, it's like, oh, somebody's offering me a Lamborghini and all I have to do is give them $2,000. Shouldn't I know that there's something going on? But then, of course, I don't want him to benefit either.
I see the issues there, Judge. I might not be dealing with the brightest individual that would be buying a car for that.
Okay, all right, thank you. All right. Do you have any children?
I do.
What are their ages?
10, 9, 7, 4, and 1.
All right. And do you have a mom? Of course, is she currently alive? That's what I mean by that.
Yes, ma'am.
Does she have a vehicle?
Yes, ma'am.
How would you like if somebody stole her vehicle and then sold it for $500 to somebody?
Wouldn't like it at all.
And how would you like it if somebody was then riding around in her vehicle? There's nothing worse than people riding around in your vehicles.
And I totally understand that. I did make a mistake.
No, you didn't make a mistake. You made a choice to steal.
I understand that.
When's the last time you had employment?
I believe it was, I can't say for sure, but it was sometime this year. I was employed at Jack in the Box.
And is Child Protective Services involved in your life at all? Do you see your children?
I do.
Gang affiliation?
No,
You just love San Antonio?
I was a young kid when I got all these tattoos.
Come on now, what does it mean? Are you just really that enamored with San Antonio and you have to remember where you're from?
That's why I mean, just because I'm from San Antonio, there's no gang affiliations. I mean, I've been on gang probation. They've never found anything like that. I don't know if I said any of that.
And if you're released, who would you be staying with?
Brother.
All right, this is what the court is going to do. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years, regular reporting by Zoom or in person, restitution, if any, and no contact with Ajane Easter, and restitution of $500 to Joshua Ochoa, proof of employment within 30 days, no employment as a home health care provider or with minors, the CATS theft course, 150 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service restitution will be deemed satisfied. Field visits 1 time per month for 6 months. Gang evaluation. probation, is there anything else? I'm sorry, regular random UAs. Anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certificate? I'm sorry, and there's a $2,000 fine probated.
Thank you.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Did.
Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Understood.
All right, good luck to you.
Thank
Don't
you.
steal.
Thank you.
All right,
Thank you.
you're welcome. And then we have your other client.
Yes, ma'am. Want to bring him up?
Yes.
Come on up.
See, people are just like, we're getting punch drunk over here.
Happens about this time of day.
Okay, there's that. All right, and you can give that to probation. There too, please.
Yes, Judge.
All right,
Substantially similar, but yeah.
all right, thank you. And yeah, this goes with that too. And all right, court is calling 2024 CR 2071 and 2024 CR 007676, State versus Hank Maldonado. Can I have parties announced for the record? State, defense,
David McLean for the defense.
and are you Mr. Maldonado? You're gonna need to speak up.
Yes, Judge.
Counsel, in each of the cause numbers, have you received all of the discovery and did you review it with your client?
I have, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Maldonado, on each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, sir.
Counsel, in each cause number, do you waive the reading of the indictment?
I do, Your Honor.
State, and the cause number ending in 2071, are you proceeding on the indictment as presented?
Yes, Your Honor.
And in the cause number ending in 7676, are you proceeding on the indictment as presented?
No, Your Honor. State's proceeding only on count one. No
Any
objection,
objection
Judge.
to the waiver of count two?
No objection, Your Honor.
In each cause number, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
I do.
All right, in each cause number, you charge, just one moment, with the offense of unauthorized use of a vehicle, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? You're gonna need to keep your voice up.
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did, Judge.
In each cause number, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, I
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
did, Judge.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Maldonado, on each of the cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
And are you a U.S. citizen?
Yes.
And counsel, in each cause number, is he also applying for deferred adjudication?
He is, Your Honor.
And each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of these cause numbers?
Yes, I did, Judge.
According to the plea, punishment is to be assessed at a cap of 12 years in the state jail facility.
12 months.
I'm sorry, 12 years. See, I was just trying to see if you were paying attention.
Pass
12
it
months.
Later.
12 months in the state jail facility. There's a $1,000 fine and the cause number ending in 2071. The state is opposed to your applications. The cases are to run concurrently. The state will take in consideration 2024 CR 1034, and there's to be restitution to Felix Francisco Centino Rivas, Richard Anthony Johnston. Did you understand that to be the plea in each cause number?
Yes, I did.
All right, is that the plea, defense?
That is, Judge.
State, is that the plea?
For the case that we're asking to be taken into consideration, it should end in 1039.
All right, so the state being taken in consideration, I have 2024 CR 1039, and I also have 2024 CR 1034. Is that incorrect?
I think 134 is incorrect.
It
There should be 139 in both of them, Judge.
All right, any objection to the state? I'm sorry, to the court making that correction?
No objection, Judge.
No, Judge.
All right, so in each cause number, the case being taken in consideration is 2024 CR 1039. Is that correct?
That is correct, Judge.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2024 CR 2071, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2024 CR 007676, how do you plead? To count one.
No contest.
State any evidence.
For each case, the state offers State's Exhibit 1 with attachments.
Your Honor, I reviewed that with my client. We have no objections.
Did you review the waivers in each of these cause numbers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So if you want, I can have a PSI report done. But then he's probably going to come back in the new year because it's going to be 8 weeks. Or if you all would like, I can have it come back sooner and I'll require a NCIC, TCIC from the state. And then you can present whatever witnesses you would like to have presented.
Okay. We can go on the record real briefly.
Yes, we'll go on the record.
Your Honor, My client has asked me to address, I believe he's remanded without bond right now on these cases. My client has asked me to try to inquire from the court whether or not the court would be willing to set a bond on these cases so that his intent is to try to convince this court that he is worthy of being on probation. He feels that he could do that while being on bond and doing his PSI and, you know, his staff evaluation. He would like to be able to show the court that he can do that successfully.
All right, well, what I'll do is I'll set it for PSI and then you can get with the coordinator and we can set it for a hearing, to have a hearing on bond issues.
Okay, Judge.
All right, Ms. Ferguson, I need a PSI date. All right, January 9th.
And Judge, on that, can we go off the record real quick?
Yes,
Court knows I got surgery coming up on December 5th.
yes.
I'm hoping to be back in action by first part of January.
Okay.
If for whatever reason I'm not, could I do this by Zoom?
Yes.
Awesome. Awesome.
Okay. All right, so we'll do PSI and TAP evaluation, probation on that case. And then what we'll do, and you all can do a referral. Do you have any drug issues?
No.
All right, so just PSI and TAP. And we'll come back on January 9th, and then counsel, you can speak with Ms. Ferguson to get a hearing for any motions to be heard.
I'll get that followed right away.
All right, thank you.
Okay, thank you, Your Honor.
Thank you.
All right, thank you.
All the day. Okay.
All right, do we have 40 more people? Bye. We'll be back on Monday.